Provincial Prosecutor of Albay versus Lobiano. GR number 224803, January 25, 2023. Facts. Jelen Galino, a minor, willingly left with Angeline, also a minor, because of the belief that she will be working in a restaurant in Legazpi City. To her surprise, Angeline brought her to Sampaguita Bar in Sorsogon, where she was expected to work as a gyro. Angeline assured to Mari Vic, the owner of Sampaguita Bar, that Jelen is 19 years old. As a gyro, she was required to drink alcohol and entertain customers, which involved kissing and other lascivious conduct. The OCP found probable cause to indict Mari Vic for the crime of qualified trafficking of persons defined under Section 6. In relation to Section 4A of RA number 9208, as amended. However, RDC dismissed the case outright for lack of evidence to establish probable cause to justify the issuance of a warrant of arrest. Issue: whether the CEA erred when it dismissed outright the petition for certiorari filed by the Provincial Prosecutor. Ruling: in Kajipe versus People, the court pronounced that the CEA should have dismissed the petition for certiorari for being the wrong remedy, considering that an appeal may be taken in a criminal action from a judgment or final order, like the RDC's order dismissing the case for lack of probable cause. Similarly, in Domingo versus Macapagal, the court declared that petition for certiorari is an improper remedy to question the dismissal of a criminal information based on lack of probable cause, because the same is a final judgment. However, the court finds that the CEA erred when it dismissed the petition for certiorari outright. In Santos versus Orta, Jr., the court enumerated instances when a petition for certiorari may be entertained despite being the wrong remedy. To be sure, a petition for certiorari is dismissible for being the wrong remedy. Indeed, we have noted a number of exceptions to this general rule, to wit: 1. When public welfare and the advancement of public policy dictate. 2. When the broader interest of justice so requires. 3. When the writs issued are null and void. 4. When the questioned order amounts to an oppressive exercise of judicial authority. 5. When for persuasive reasons. The rules may be relaxed to relieve a litigant of an injustice not commensurate with his failure to comply with the prescribed procedure. Or 6. In other meritorious cases. The instant case involves a charge of human trafficking, a crime that this court has described as so abhorrent and reprehensible that is characterized by sexual violence and slavery. Clearly, the case involves public interest, and public policy and welfare justify giving due course to the petition for certiorari. In fact, in Young versus People, a case involving similar circumstances, resort to a petition for certiorari was allowed in the CA to question the RDC's dismissal of a human trafficking case for lack of probable cause.